Just before we start again, Ms. Richards, let me just mention to those who are watching remotely that those who are hoping to watch on YouTube may have missed the first 10 minutes of our proceedings this morning. They can be assured that the full YouTube will be uploaded after today. There was a technical hitch which affected that but did not affect the Zoom presentation. My apologies to anyone who may have been discomforted by that. Ms. Richards.
Mr. Stevens, the Eileen Trust was set up in 1993. You joined a few years later in 1999. How did it come about that you joined the Eileen Trust as trustee and chair?
I was invited to by Alan Tanner and Cliff Grimstead when they asked me to rejoin the McFarlane Trust. They said, and by the way, you join the Eileen Trust as well, and take over as chair of that when Alan stepped down from there as well.
Now obviously, the trust or scheme was already established, and we will be hearing from a couple of other witnesses relating to the Eileen Trust. But I do just want to ask you to look with me at the original scheme document and ask a couple of questions about that. It's EILN 5016_001. Now, this is the scheme, I think, for England, Wales and Northern Ireland. There was a separate but not dissimilar document covering Scotland. It's entitled Scheme of Payments for Those Infected with HIV through Blood or Tissue Transfer. And that, as I understand it, is why in your statement you refer to the Eileen Trust as the scheme, because that's how it was so described in the founding documents. Is that right?
If I did so refer to the trust in my document, then that was a mistake. I tried to distinguish the scheme from the Eileen Trust. That's my intention anyway. So if I use those terms in any stage interchangeably, then that was a mistake.
Well, it may be my misunderstanding there, Mr. Stevens. Can you just tell us then what the difference was between the scheme and the trust?
Yes. And I think I can only do so by referring backwards to the McFarlane Trust in its early days. In the case of the Eileen Trust, the scheme was set up by the Department of Health. I don't know at whose instigation, but it may have been, the push might have come from the Haemophilia Society, which is rather strange. The scheme of payments follows precisely the tariff categories established for the McFarlane Trust settlement payment which was administered by MSPT2. The amounts of money attached to the tariff, the Eileen Trust scheme, I've done it already, with the scheme, were the same as the MSPT2 payments plus the MSPT1 £20,000 ex gratia payment. So, adding those two together, the scheme of payments that we're looking at here was identical to the MSPT 1 and 2 payments. And then in the second page or third page of this document, second page of the text of this document, I think there's reference to the intention to set up a, they're called a special needs fund, which became the Eileen Trust, that was set up the following year. The scheme document set a very, very tight timetable for applications. I think based on the belief that most or all people who would apply would be relatives of those who had already died as a result of a blood transfusion received, I think typically during postpartum hemorrhage. But there were never many applicants for Eileen Trust. Probably about 100. Dozens of those who were early recipients of payments from the scheme had already died. And I believe that the very tight timetable and the general lack of publicity and the fact that the Eileen Trust was set up outside the period of that timetable were designed to deter estates from approaching Eileen Trust for assistance. Unfortunately for the architects of the scheme, they put in a let out for the timetable so that people were able to join the scheme and the Eileen Trust many, many years later. The idea of the scheme was that people would be adjudged whether or not they were eligible for payments from the scheme. If they were, and they received those payments from the Department of Health, then they were eligible to apply for help to the Special Needs Fund that became the Eileen Trust. There was a considerable period when the scheme payments were channeled to the beneficiaries through the Eileen Trust, in which we, the Eileen Trust, the word is connived, without realising that actually by doing so we were in breach of our charitable undertakings. It took a long time for the exact relationship between Eileen Trust and the scheme to be fully understood. And to my shame, it took me a long time to understand that the Eileen Trust was not, as it had been seen right from the outset, a mini NFT, but was actually something totally different. The circumstances in which people were infected were totally different. None of them had bleeding disorders. Well, actually, one did. One lady had thalassemia, which is a sort of bleeding disorder. They had totally different expectations, totally different needs. It took a long, long time to get out of the habit of thinking of the Eileen Trust as a mini NFT. We eventually got there, and looking back, I mean, the Eileen Trust was brilliant in many ways, and the Eileen Trust community were lovely people. But my only regret is that I didn't wake up early enough to realise that Eileen Trust and MFG were so totally different and had to be handled totally differently. Even in the present century, the Haemophilia Society seemed to be expecting to have the right to nominate trustees to the Eileen Trust. Had nothing to do with Haemophilia Society at all. So it is very strange. And the relationship between the scheme and the Eileen Trust was, I think, probably improperly understood by the Department of Health. So that the scheme became known as the Island Trust scheme, we had no means of knowing, of judging applications for the Island Trust who had to prove that their HIV infection arose from the receipt of blood, could have been tissue, but it was always blood, through NHS treatment. That job had to be done by the department, and they didn't have the department of the department on whom this burden fell were not equipped to make these judgments, make these assessments. So it's very awkward. There was a period when we were saying that, I'm sorry, I'm rambling a bit, when we were saying that unlike McFarland Trust, people could be coming to the scheme and then to the Island Trust for years and years and years to come. I think that is no longer true, because I think anybody who was infected with HIV through blood transfusions in the early to mid 80s and had not been diagnosed by now would be dead by now. The last registrant we had in the Island Trust, as I can recall, was, I think, in the first decade of the century, the noughties, or whatever they're called, who was infected through a contaminated transfusion given to her this century. And the hospital that gave her that contaminated transfusion recognized the error and paid her a stonking amount of money. So there could be no question that she qualified for assistance, which she should not have received, because that was a stonking amount of money, had her children not made off with the money and left her destitute. So she required assistance from the Island Trust and received it. But the previous applicant, who was infected during the 80s, I think came to us in the early 2000s, probably. I don't think we had anybody later than that, but I might be wrong there.
So just
sorry, that's a rambling answer.
That's okay. Just so that I can understand clearly, eligibility for the scheme, whether someone was a qualifying person, was a matter for determination by the Secretary of State. You've expressed your view as to the department's lack of expertise, so to determine. But the scheme was they would decide, and then the Eileen Trust would then accept that person as a person in principle eligible to make applications to the trust for discretionary payments.
That's correct. Hold on.
Now the Eileen Trust, I think we can see if we look at EILN 4016_053. See, it was a much smaller trust in terms of the numbers of registrants.
I think we may be missing a zero.
I think we may. So EILN 5016_053. My apologies. So this is the annual report for the year ending 31st of March 2001. So probably roughly your first year as chair, or the early part of your time as chair. If we go to the third page, we can just see, if we're going to the top part of the page, first of all, objectives. The Eileen Trust was established in '93 to administer a fund provided by HMG to assist people other than those with haemophilia who'd contracted HIV through NHS treatment with contaminated blood products. The Trust's objectives as set out in the Trust Deed are to relieve those qualifying persons who are in need of assistance or the needy dependents of qualifying persons and the needy dependents of qualifying persons who've died. And then we can see that as at 2001, the Trust is providing assistance to a small number of registrants. The second paragraph below Trust's task tells us there were 10 registrants and 2 infected intimates at that point being supported, and that you've been notified of a further possible registrant, and 9 families of deceased registrants involving 13 children under 18, together with a further 3 young people under 25. And then the next paragraph tells us, in addition to the provision of financial support, the Trust provides a range of advice and counselling for partners and families who've been bereaved. A number of children and young people for whom the Trust provides assistance are orphans, whom the trustees and staff make special efforts to help in whatever way is possible, and then reference is made to the staff team, including a social worker and benefits advisor. The document there makes particular reference to orphans, and we've seen in relation to the McFarlane Trust documents that there was no particular policy in relation to orphans. Was there in practice any difference of treatment between orphans who were qualifying persons under the Eileen Trust and those who were beneficiaries under the McFarlane Trust?
I don't know, but the proportion of the Eileen Trust community who were orphans was very much higher than for the McFarlane Trust, because the core constituent of the beneficiary community was deceased mothers. So there were a lot of children left without mothers, and some of them without fathers as well. So whether there was a difference in treatment, I couldn't tell you. I don't. But it was a much more prominent problem for the Eileen Trust than it was for the McFarlane Trust.
Do you know what steps were taken by the department, or indeed by the Trust from time to time to ensure that doctors were aware of the existence of the scheme and to try and reach out to potential qualifying persons?
I think efforts by the department were conspicuous by their absence. We would occasionally say to the department, we on the Eileen Trust would occasionally say to the department, there must be another push to find people. And they would, from time to time, in response to these nudges, they would include some reference in there's one of their regular monthly or weekly bulletins they put round hospitals and doctors, and they would mention it. But I can't remember when the last one was. It was a long time ago. I'm not going to say that because my memory is failing, but I don't think there was. This is not a high priority for the department.
Was there ever any problem with the department taking a long time to process applications by potential qualifying persons?
Well, certainly in the later years, during my chairmanship, yes. I mean, there were 2 applications that I think took 2 years, simply because the applicants were both men, believed that they had received infected, contaminated transfusions. I think one of them didn't know where, didn't know when, had moved around so many times that he had no records. It was very, very. It was a very difficult case, but he got no help from the department at all. The other one knew which hospital he believed he had been injected in. I knew roughly when, but again there were no records. The records had been destroyed. I think he changed GPs sufficiently that there were no discharge notes anywhere. So these applications took a couple of years without any help from the department at all. The trust, through our caseworker Susan Daniels, gave such help as we could in saying, have you tried this, have you tried that? In the end, neither of them was accepted for the scheme, therefore they didn't become trust beneficiaries. I thought that one of those assessments was probably correct. I have my doubts about the other one, but there's no means of proving it.
If we have a look at EILN 607_012, please. So this is, I think, an internal Eileen Trust document.
I think this probably precedes my involvement, but I don't know.
Yes, it's not dated and it's not signed, but I don't think anything perhaps would have changed. So we can see it's.
I remember all the names of those of the office staff there.
So it's described as a small organisation in the second paragraph, and then we see under the heading policies, says the trust is small, trustees and staff deal with any request for help on its own merits and subject only to the terms of the trust deed and charity law. This means that financial help must be related to need. In this context, need recognised will mainly be related to the additional costs of living with HIV or to maintaining health or to the care of sickness which is not otherwise provided for. And then there's a reference again to office guidelines, and to that not being exhaustive. Trustees will consider all applications for help that fall outside these guidelines. That suggests a fairly similar approach in general terms, at least, to the approach taken by the Macfarlane Trust.
Well, as I used the phrase earlier, it was run, certainly before I became involved and even after I became involved, it was run like a mini NFT. The guidelines documents are precisely the same as those that Macfarlane Trust used. They're just, it's just looking back now, which is, as I said earlier, it is a source of regret to me that I didn't understand the difference between the two trusts and the two beneficiaries communities early enough. I suppose when I was concentrating on being chairman of the Macfarlane Trust, I was carrying on with the same sort of philosophy that had guided the handling of the Eileen Trust in its early years. It took a long time for me to get round to understanding it as different.
I want to come back to that issue. I just want to ascertain at first what in practical terms the Eileen Trust did and how it operated. If we look further down the page, we can see that the help available, the financial help available, was comprised grants, and then if we go over the page, we can see regular payments and then winter payments. So that same three different types of financial support.
Same as the Macfarlane Trust.
But then if we go to the bottom of the page, other help available, it says a significant part of the trust service is not necessarily concerned with direct financial help at all. Advice and information are always available either by telephone or letter. With a qualified social worker and benefits advisor on staff, we have considerable experience and expertise on, and then a number of matters listed there. And if we go to the top of the next page, it said that first level advice and further action can be recommended on matters such as insurance problems, mortgages, wills, etc. And then we're not able to offer a full counselling service, but if you would like to discuss any problem with someone who can lend a friendly and discreet ear, then please ring the telephone number given. Now, was that kind of practical, non-financial advice, information and support unique to the Eileen Trust because of its small nature and small number of registrants, or was it equally something that was delivered through the Macfarlane Trust, or intended to be delivered through the Macfarlane Trust?
Well, given the same people were involved, the same providers of advice were the same, the two trusts, because they were just the same people, services would have been available for the Macfarlane Trust, but the Macfarlane Trust, because it had so many more people as in the beneficiary community, could have swamped those people in the Alliance House who were giving out help to the Island, offering help to the Island Trust. So I suspect that this document, while it could easily have been written for the Macfarlane Trust, probably the Macfarlane Trust would not have been quite so forthcoming by saying this advice and this help, this counselling was available.
Just see if I've correctly understood that. In principle, the same advice and assistance was available to both Eileen Trust and Macfarlane Trust beneficiaries. In practice, because the Eileen Trust was dealing with a very small number of beneficiaries and the Macfarlane Trust had a much larger number, it was easier, I don't mean that in a pejorative sense, I'm just trying to establish the facts, it was easier to potentially to make that available to all recipients of the Eileen Trust.
I think the other consideration is that the majority of the Macfarlane Trust registrants had a first port of call, which is their haemophilia centre. Eileen Trust registrants had nothing like that at all. They didn't have ongoing relationships, except one or two cases, with the hospital. They didn't have a dedicated centre like the haemophilia centres, so they would have had nowhere else to go, nowhere else to turn to except the Eileen Trust. The Macfarlane Trust registrants had. Sorry about that. We have that's our local fish delivery from Grimsby, trying to get into the community.
If we go to EILN 5011_197, it's a report from Susan Daniels, 27th of September 2004. If we just look at the first paragraph, it says the financial advisor has made a visit to a widow near blank, which arose as a result of the chairman's request to contact ET registrants offering assistance. Now, it sounds from that as though there'd been a request from you proactively for the financial advisor to make contact with Eileen Trust registrants to see what assistance they needed. Can you recall anything about whether the Eileen Trust took a more proactive approach than the Macfarlane Trust was able to?
I think we yes, I mean that certainly that happened because we're only dealing with a couple of dozen people. So we were able to be proactive. We were able to make sure that there were good contacts, and there are several there more than one referred to there. The final paragraph that's on the screen, 5087, I visited them with Susan quite early on in my period as chairman. Particularly difficult, or the family were not difficult, the relationships in the family were difficult. So yeah, it was something we were able to do in the Eileen Trust because the numbers are manageable.
In your witness statement, if we go to WITN 307-0003, please. And we go to page 30. You say in paragraph 156, which is the second paragraph on the top of the page, this is on the issue of operational costs. Until 2009, operational costs of MFT and ET were funded by the Department of Health through a specific grant mechanism called Section 64. And then you explain that from 2009 onwards, the method changed so that the trust would receive an overall annual settlement, which was for both operational costs and for the financial assistance provided to dependents. I'm not going to ask you about the impact on Macfarlane because you'd left by then. In relation to the Eileen Trust, you say that this change resulted in a substantial reduction in overall funding levels. Were representations made to the department about that?
Well, of course. If you recall from yesterday, the offer, the response by Caroline Flint to a joint bid for further funding and an increase in funding by both trusts was met with something that was frankly insulting, where she said she was satisfied that an increase of 11%, which wasn't, of course, 11%, we showed you yesterday, just over 3%, was enough. I mean, just, yeah. The Eileen Trust went through exactly the same processes in the Macfarlane Trust in requesting, demanding more money. And if you're going to suggest that we should have had a public relations campaign on behalf of 2 dozen people or fewer, I think we needn't go there.
What practical difficulties did this result in for the Eileen Trust? This change in the mechanism of funding of operational costs.
Well, we had to be more. We had to take a tougher line on grant allocation. Fortunately, Susan Daniels made a huge contribution by running the Eileen, taking the Eileen Trust to run from home. So we had very little contact or call on Macfarlane, on the services of Eileen of Alliance House, and I was able to agree with Martin Harvey that the charge that initially Macfarlane Trust and then later Caxton made to Eileen Trust was considerably reduced in order to reflect the saving of costs. So we got by, we managed.
If we go to EILN 603_146, please. And this letter predates the change in the scheme of funding to which your statement referred, but it's nonetheless a letter from you about funding difficulties. It may follow on, I think, from the Caroline Flint decision. It's referred, it's headed Eileen Trust funding for 2007-2008. Second paragraph refers to the funding award to the Eileen Trust being as unacceptable to the trustees as the Macfarlane Trust award was. You then refer to there being what's said to be important differences between the trusts, which enhance the belief of your fellow trustees that the department have adopted a formulaic approach that totally neglected the nature and history of the trust and the policy hitherto adopted by ministers towards its funding. What were those differences relating to the nature and history of the trust and the prior policy of its funding that you were concerned about?
Well, the key differences between the trusts were that the McFarlane Trust started off with 1,254 registrants. I think 2 or 3 new ones came along after that in the early years. Eileen Trust says in the highlighting of the paragraph I'm making.
So if we just remove the highlighting.
Thank you. There we are. The Trust has received no fewer than 5 new registrants in the last 3 years. So, I mean, McFarlane Trust had nothing like that. So there can be no confidence that further new registrants will not come to life in the future, and some did. So that's the key difference, is that Eileen Trust was beneficiary community was grow or had a tendency to grow, which was offset only by, unfortunately, mortality.
If we go over the page,
I think that's the most important one.
If we go over the page. Sorry, actually, I need to pick this up at the bottom of the page. I think it's something you've referred to earlier in your evidence, but I wanted to double check. We go to the bottom of the first page. Sorry, Shumik. You refer there to the scheme and say the department committed to a range of capital payments along the lines of those made to McFarlane Trust registrants through MSPT2. And then top of the next page, you say the funding award for 2007-8 attempts to transfer the responsibility for making these payments to this trust without the provision of any funds to finance them. What was the issue there, please?
Well, the department said that any payments under the scheme to new registrants should be made by the trust, and the department won't fund those. That's got to come out of your normal funding allocation. I mean, it's just insupportable. I mean, with two new registrants in a year who would wipe out completely the whole funding allocation for the year.
So the department's expectation. The department's expectation.
I'm sorry. Ludicrous suggestion.
So the department's expectation had been that the tariff payments that were due under the scheme, would be paid by the trust out of its existing allocation. That's
what they were suggesting, yeah.
Did they back down from that?
I think they did, yes. I think the result of this letter was, I would say underneath the bullet points, the element of the funding award betrays inadequate thought within your department. I think they did actually rethink that and agreed that any new payments by the scheme would be financed directly by the department.
And do you recall whether you had any meetings with ministers in relation to the funding of the Eileen Trust? So after the Caroline Flint meeting we've discussed yesterday, after you ceased being chair of the McFarlane Trust, but continued with your role with the Eileen Trust, did you have any subsequent funding meetings with ministers that you can recall?
I can't recall. I probably did, yes. I hope I did, yeah. If you were to tell me who the ministers were who followed Caroline Flint, then I would say whether I met them or not.
I'm afraid I don't have them off the top of my head. But if we then go, please, to your evidence to the Archer inquiry in relation to the Eileen Trust, to ask you to look first at the written document you prepared. It's ARCH 302992, please. So if we go to the second page, and we pick it up in the third paragraph, we can see you saying the department's made occasional efforts to alert medical practitioners to the existence of ET and therefore to the possibility of finding patients who were infected through NHS treatment during the 80s. It's questionable whether this work has been sufficient given the risks of onwards transmission of the infection from those affected. And then you refer to awareness of new application for registration. You're here raising that issue with the Archer inquiry. Had the Trust, through you or your colleagues, previously pressed the department to make more strenuous efforts to alert medical practitioners?
We already covered this, yes.
But was that something that was raised in regular meetings by you?
It was certainly raised. I can't say that we had regular meetings. It was certainly raised, yes.
And then you say in the following paragraph, picking up in the end of the second line, the smaller numbers have enabled the trustees to develop a much closer knowledge of each individual registrant's circumstances than is possible within MFT. It's probably fair to say that ET now gives a more personal service to its beneficiaries than MFT has ever managed with the help of a dedicated case worker. So that's the more bespoke personal service that you were able to provide, potentially sometimes anticipating future needs because of the smaller number of registrants.
Yes.
And then if we go to the bottom of the third page, please. You say in the last paragraph, you refer in the previous paragraph to the issue that I asked you about a few minutes ago, but you then refer to the capital payments, saying that they were, by modern standards and by comparison with those made in other countries, very small. The tariff for the ET settlement payments also discriminates against those who were still minors or were unmarried or had no children. Just pausing there, that's presumably an observation equally applicable to McFarlane Trust settlement payments.
Yes, I think many in the McFarlane Trust beneficiary community felt these criticisms in relationship to the MSPT2 settlement payment very strongly, because the settlement payment was difficult for MFT registrants to argue against because it was agreed by their legal representatives.
And then if we go to the next page, top half of the page, under the heading The Benefit System, you say this: it's always been the belief of ET trustees and registrants that the trust was the first line of support for its registrants. And then you observe it was constrained by level of resources available, so that registrants also needed to have recourse to the benefit system. Now that appears to be the opposite from the position we discussed yesterday in relation to the McFarlane Trust, where the McFarlane Trust was seen as last resort.
Yes.
Why that difference of approach?
I don't know. I'm not sure that that first paragraph is entirely accurate. I think certainly even in Eileen Trust we would say to people who wanted our help, have you been anywhere? Have you tried the social fund, for example? Have you tried your local council? We would always ask people went somewhere else and looked at us as the fallback.
Because I haven't done a comparison of the trust deeds, but broadly speaking, the Eileen Trust and the McFarlane Trust were both charitable trusts with need as their primary object. So there'd be no...
The core wording of the two trustees was almost identical.
And then I want to look at something you said in your oral evidence to the Archer inquiry. So if we could go, please, Shomik, to ARCH 605. And if we go to page 27, the electronic pagination. Yes, so if we pick it up at line 9 onwards, you say this. There is an additional issue as regards the Eileen Trust, which makes it unique, I think, or makes it different from the Macfarlane Trust. Registrants to the Eileen Trust were infected through blood transfusions. I'm not a medical Hurst original, but I believe blood transfusions have been going on for centuries, and that the treatments that these people were receiving were not being provided by haematology. They were being provided by orthopaedic surgeons, by heart specialists, whatever, a range of clinicians who would reasonably expect, if their patient required a blood transfusion, that the blood transfusion would not be a source of infection. They could not be expected to know that they were actually putting a life-threatening treatment into their patients. To my mind, this makes the Department of Health even more responsible for the condition of the Eileen Trust. If we go over the page, registrants. I'm not talking liability which can be discharged. I'm not talking blame which can be excused. I'm not talking accountability which can be referred upstairs. I'm talking responsibility, which is permanent. I think the Department of Health are turning away from their responsibility. They're denying responsibility for the Eileen Trust registrants by cutting back the funding, by refusing to give adequate funding to the individuals as well as to the Trust. It's a total abdication of responsibility. Now, why was it your view that the Department of Health was more responsible, or even more responsible, for the position in which Eileen Trust registrants found themselves in than Macfarlane Trust registrants?
Well, my reasoning is set out in the previous paragraph, previous page. I'm saying that the people who administered transfusions were not haematologists. So they were taking it on trust that the transfusions were appropriate for their circumstances. I mean, this may not be the way the National Health Service works. These are my views. The page we're looking at the moment, my little dissertation on liability, accountability, responsibility, blame, something which I hope may be right. There's, I mean, that argument was something which I assume the inquiry might consider. But as far as I'm concerned, the people who administered the transfusions to the Eileen Trust registrants transfusions that turned out to be contaminated, would not have expected them to be contaminated, and therefore it seemed to me that the Department of Health were even more responsible than they might have been for haemophilia, the infection of haemophiliacs. But this is what the inquiry is set up to do. And so I'm only saying these are my arguments. You can dismiss them if you like.
What I'm trying to understand, Mr. Stevens, is the basis for suggesting that your basis for suggesting the Eileen Trust's position was unique. The relative knowledge of the doctors who administered the treatment. Why does that make the position of one set of patients more deserving of recompense or recognition or acceptance of responsibility than another set?
I'm not sure I'm saying that, am I? I'm saying that I believe the Department of Health are more responsible because there were no, and I may be wrong here, totally in the way the NHS is set up, but there were no haematologists who were involved in the administration of transfusions to Eileen Trust or scheme registrants eventually. The people the Eileen Trust were looking after were infected on the basis of a single transfusion. I would not expect a thoracic surgeon to know the background of blood contamination. I mean, maybe I am misjudging the breadth of knowledge and the involvement of people who would know in those operations. But it seems to me that what I was saying there, and I think I probably would still say that now, it seems to me that whereas the Department of Health, whatever the inquiry finds out, had a broad responsibility for the use of contaminated blood for blood products that were administered over a period of years as a matter of course by experienced haematologists to people with haemophilia. The people who gave single transfusions to people for the treatment of non-chronic conditions in the course of surgery could not have been expected to know the risk that those transfusions might be contaminated, and therefore somebody somewhere has to be more responsible for that, and I believe that's the Department of Health. That's what I believe the inquiry is set up to find out, and you might find I'm totally wrong, but I'm expressing a view.
Can I just check then with this? Were you in what you told the Archer inquiry in any sense intending to suggest or hint that the patients who were haemophiliacs themselves bore some level of responsibility because they should have known of the risks?
No, not at all.
Thank you.
Nothing to do with the patient. It's the people who are looking after them.
Thank you. There's then a final question on the Eileen Trust about the position of reserves towards the end of the life of the trust. So if we could look, please, at EILN 502_029.
I think I might need another note.
I think we might. In fact, actually, I don't think we need to go to that document. We'll go to a slightly later one, which makes the same point. EILN 602_026. So these are the minutes of a board meeting on the Eileen Trust on the 7th of September 2017. And we can see, if we look in the bottom half of the page, so this is in anticipation of the new scheme administrator, the NHS Business Services Authority taking over from the 1st of November. And at 3, the minutes record this: any funds remaining after the handover, other than what would be needed to finance the shutdown expenses, would be distributed between the registrants, those with the highest need receiving the most. A small payment would be made to most registrants so that they had an emergency fund. And then there's a later document I don't think I need to take you to, not long after this, where we can see the funds were reduced in that way to something less than £5,000, which was then, I think, gifted to the Macfarlane Trust. So is this right, that the Eileen Trust decided to use its remaining reserves by distributing those reserves amongst its registrants in the way in which we see described here?
Yeah.
Were you involved with, or did you have any knowledge of, the approach that was being taken at around the same time by the Macfarlane Trust to what was being done with its reserves?
Not in detail. I know that they had they had some sort of scheme to run down their reserves, which we've already discussed, with £1 million. I was not involved in the detail. I don't know.
I'm going to move then to the Skipton Fund. You've explained in your witness statement that when the Skipton Fund was being established, there'd been a dearth of preparatory work done by the relevant government officials. And you and I think Mr. Harvey had to do a lot of the preparatory work which you would have expected would be done by others. What kind of stuff did you have to do?
The broad principles of the operating practices of the Skipton Fund were, I think, agreed by the plenary meetings chaired by Richard Kotowski. Martin and I then had to go away and draw up detailed proposals to how these operating practices would actually work. Just that.
So the meetings that you described taking place, who was involved in those meetings? You, Mr. Harvey, officials from the Department of Health, and any others that you can recall?
Well, yes, I don't have a full cast list, but certainly there were representatives of the devolved administrations, health departments of the devolved administrations, one of whom was particularly helpful, some of whom were totally unhelpful. Charles Gore from the Hepatitis C Trust attended most of them. There may have been, I don't know, the Haemophilia Society may have been involved, I can't remember. I really don't know. The list of names will have to come from the department.
Now, there had been in Scotland, prior to the ministerial announcement that led to the establishment of the Skipton Fund, a report by Lord Ross and others, which made certain recommendations about compensation for individuals infected with hepatitis C from blood or blood products. Can you recall consideration being given to that report in these meetings that took place?
No, I can't.
The Skipton Fund, as you've explained in your statement, and we'll look at some documents as necessary, was a scheme, a fund whereby payments were made that were predetermined payments, stage 1 and stage 2. Were you involved in these plenary meetings that you've discussed in discussions about whether that was the right approach to take, or had that been determined prior to your involvement?
I can't remember exactly. I have the feeling that there was discussion in these meetings about the idea of a two-stage approach and what the quantum of the payment should be. I think the meetings probably rubber stamped, at least if they didn't actually make a decision, they probably rubber stamped that decision. I don't believe I had a particularly strong view. I mean, I spent quite a lot of the time in these meetings trying to catch up with what hepatitis C was about and how it worked, and some of the medical evidence was quite difficult to understand, for me anyway.
one of the recommendations of the Scottish report, the Ross report, had been for there to be payments made effectively beyond a certain, or to some categories of patients, on a full compensation basis. Can you recall whether there were any discussions about whether that a compensation principle should or should not form part of the Skipton Fund approach?
I don't recall the word compensation being allowed to be uttered in the precinct of Richmond House. So, no, I don't think that... I think the idea that was being discussed in those plenary meetings was always some ex gratia payments to help people deal with the effects of infection. Certainly not the C word.
And do you recall any discussions about why the Skipton Fund was going to operate on a national scale rather than there being schemes run directly by devolved administrations?
Oh, I think there was discussion. I think it was broadly accepted that there couldn't be. It was totally inappropriate that the devolved administration should have their own schemes, and people would be. I think it was felt that this had to be done on a UK-wide basis for reasons of efficiency and probably equity.
If we go to SKIP 5032_214, this is an email from you to Moira Pratani, who I think was a solicitor advising.
This is the meeting, yes.
Yeah, 10th of November 2003. You refer to having had, in speech marks, the secret meeting at the Department of Health, the secret being that the haemophilia, people such as the Haemophilia Society were not involved, and we were being given an advance warning of what's now planned. Can you recall why a meeting was taking place in the absence of what you describe as people such as the Haemophilia Society?
If there was any discussion of it at all, I mean, I cover this in my written statement. I don't recall it, but the meeting participants were invited by Richard Gutowski, and I suspect the reason the Haemophilia Society were not involved was because a large proportion, it turned out to be about half of the beneficiaries of the Skipton Fund were not people with haemophilia. So that he was anxious that what we were talking about at this meeting was covered in that note should not be overly concerned with people with haemophilia.
Okay, and then if we look at the bottom half of the page.
Sorry, just to say, who attended this meeting was not my call.
If we look at the bottom half of the page, it's 3 indented paragraphs up from the bottom where it begins, there would be no payments to bereaved families or to those who've cleared the virus naturally. The first of these in particular is regarded as unacceptable by the Haemophilia Society and its political allies, so there might be continued campaigning on it. This could put certain MFT trustees in a difficult position. For my part as a society-appointed trustee, I can live with the NHS making ex gratia payments with no admission of liability to people it has harmed who are still alive and are or will be incurring costs as a result of their infection, while ignoring what would seem a bit more like compensation who have been bereaved, even in those cases where such bereavement has resulted in real financial hardship. What was your understanding of the rationale for the department's resistance to assisting the bereaved?
I don't know. I mean, subsequently the scheme was changed to to admit people into the scheme. So why the department started off with that as a basis? Sorry, I can't remember. You know, maybe on the basis that they thought they could get away with it. I don't know. I don't know why. You haven't asked about the omission or the exclusion of those who clear the virus naturally. I don't understand why that.
I'm going to come on to that
Yeah,
in a few minutes.
I don't know why that came along.
Yeah, I'll come back to that. If we could have SCGV 40256_051, please.
Just to say on that previous note, just glancing through it, there are several points in that note, which was written towards the end of 2003, that did not, on which the scheme was different from what eventually happened. Some of those original assumptions were just discarded. Anyway, sorry.
No, that's right. So there are some. This is some email exchanges between various of those involved in discussions. If we go to the second page, we can see there's an email from you to Richard Gutowski at the Department of Health. And if we go towards the bottom of the page, you'll see the reference there to Hep B. It says, this is a new point, again from Mark. I think that's from Dr. Mark Winter. He has 2 or 3 haemophiliac patients who contracted Hep B through the same route. It would seem logical to include them since numbers are bound to be very low. Can they be included through the administrative process without being publicly announced? Can you recall there being any more substantive discussion other than you, as it were, floating the point here, about the inclusion of hepatitis B sufferers and why they were not included?
No, I can't recall any discussion, but my understanding is that this point was dismissed. It was not. I don't believe hepatitis B was accepted as something with which Skipton should be concerned.
That can go down. Thank you. Can you recall again any discussions about why the Skipton Fund was going to be structured as a company, limited company, rather than some other form? We've seen trusts as the basis for Macfarlane and Eileen so far.
Well, Skipton was performing a totally non-discretionary, non-charitable act. It was simply going to be operating to administer a scheme. So there had to be some sort of vehicle for it. I think by the early part of the 21st century, the alacrity with which trusts were considered appropriate vehicles had rather diminished. And it was natural to think of a corporate vehicle. So a company limited by guarantee didn't require anybody to put up any money for it. It was just seemed to be a totally appropriate vehicle.
Can you recall any of the detail of the discussions about the amounts of the payments, the lump sum payments that were going to be administered by the Skipton, and how?
No, I can't recall any detail. I'm sure there probably was discussion. I can't recall any of the detail.
Can I then come on to the issue you alluded to a moment or two ago, which was that of natural clearers? Did you get any understanding of why there was resistance to including natural clearers within the scheme?
No, I think for once I've got to admit that this was not exclusively the Department of Health's insistence. I think there was support for this from some of the clinicians at those meetings. It was I mean, it was a very difficult issue, and I pulled out some note that the first glimmerings of daylight on this were in 2011, which was 7 years after after Skipton Fund began operating. It was an extremely difficult issue, and I suppose one of the reasons why natural clearers were involved were excluded was because they would have had no ill effects from the infection. Their health, their future livelihood, their life expectancy was totally unaffected by this short period of infection during the acute stage, after which they didn't have to have any medical treatment for it. They just their bodies just threw off the infection. So I suppose that from the point of view of both clinicians and particularly the Department of Health, they said, well, why should we pay these people something that has not affected them? I suppose that's the background.
If we look at SKIP 5031_213, so this is a letter you wrote to Professor Mark Mildred, who was chair of the Skipton Appeal Panel and from whom we'll be hearing in due course, 26th of November 2007. And if we pick it up in the second paragraph, we can see you expressing the view, which I think is probably expressed here as a collective view on behalf of trustees, as something that has always been regarded as a...
Directors, not trustees.
Sorry, directors, you're right. Regarded as a defect in the ex gratia scheme, which was the exclusion, as we see from the following paragraph, of natural clearers. And if we just go further down towards the bottom of the page, you there set out that the result of this exclusion has been inequity in two respects. First, a number of leading hospitals with major and experienced haemophilia treatment centres have made no applications on behalf of any of their patients with haemophilia who, we'll go to the top of the next page, have cleared the virus naturally, believing that they're unable to distinguish with any scientific accuracy between those who cleared the virus during the acute phase and those whose clearance occurred later. On the other hand, other similar institutions appear to have taken the view that any of their natural clearers were likely to have had chronic stage infection. And then you raise a second issue relating to a particular applicant in a particular set of circumstances. First of all, do you know whether Professor Mildred took up the invitation to make representations to the department about the natural clearers issue?
No, I don't. I mean, it was the letter. It was totally improper to have written to him. There was no direct contact between the Appeal Panel and the fund, except that Nick Fish, who was the brilliant administrator of the fund, also handled the administration of the Appeal Panel. But he was able to keep the two subjects separate in his mind, and he did not talk to any of the directors about cases that were being put to the panel or cases that on which the panel had adjudicated. So I should not have written to Mark asking for his help. I should, but we were running out. We ran out of options. We the directors of the company were concerned that we were coming up with these cases like this young man referred to here, who met all the criteria for being natural clearers, and yet actually clearly weren't. So it was very difficult. So we were looking for somebody to help to have the policy reconsidered. And the choice of that somebody was Mark Mildred. I should not have written to him. He didn't reply to me. I had no idea whether he took it forward. I would say 4 years after this letter was written, there was a glimmering of belief that some progress was being made in the treatment of natural clearance. The bottom of what we're looking at on the screen says we've excluded about 180 applicants on the grounds of being natural clearance. I think in the end, the number was about 500. It was quite, and what it says there, what we do not know is the number who have been, and I know what it says after that, which is who have been omitted from making applications, or on whose behalf applications have not been made by their haemophilia centre. So,
And was that first inequity in which the ability to even make an application effectively depended upon, or to make a successful application effectively depended upon the policy of the haemophilia centre or clinician, was that inequity ever resolved as far as you can recall?
No, I don't think so. I think people on whose behalf applications were not made to the Skipton Fund, I don't think applications were ever made for them. Sorry, just saying their lives wouldn't have been affected by the infection anyway. So maybe that's reasonable.
Now, you described the MFT, I think earlier, as a quasi-agent of the Department of Health. The Skipton Fund was, in terms, described as an agent of the Department of Health, because it operated pursuant to an agency agreement with the department. Is that correct?
Yes, I mean, this is another illustration of the brilliance of the Department of Health. That the Skipton Fund began operating in July 2004, and the agency agreement was finally settled, drawn up, and signed in 2007. But yes, we were clearly agents. Our annual report every year started off by saying we are agents of the Department of Health.
You anticipated my next question, Mr. Stevens, which is why did it take nearly 3 years from when the fund first started operating for the agency agreement to be finalised and signed?
No idea. It wasn't our job.
It also took, we can see it from the minutes if necessary, but you may recall, it also took a considerable period of time before the department established the appeal panel, which met for the first time in October of 2006. Do you know why that took so long?
No.
Had it been the department's responsibility and not the fund's to establish the appeal panel?
Completely. The appeal panel was, as I said, it was independent of the fund. The membership was chosen by the department. The terms on which everything to do with the appeal panel was handled by the department, with the exception of the administration that Nick Fish looked after.
So I want to go to the agency agreement, but it'll take more than 1 or 2 minutes, so perhaps do that at 2 o'clock.
Yes, we'll take a break now till 2 o'clock. 2 o'clock.